Hello. Hello. We are gonna continue the reading of Constitution of India. Let's start. We'll start with Article 134A, Certificate for Appeal to the Supreme Court. Article 134A. Every High Court passing or making a judgment, decree, final order, or sentence referred to in Clause 1 of Article 132 or Clause 1 of Article 133 or Clause 1 of Article 134 may, if it deems fit to so do, on its own motion and b. Shall, if an oral application is made by or on behalf of the party aggrieved immediately after the passing or making of such judgment, decree, final order, or sentence, determine as soon as may be after such passing or making the question whether a certificate of the nature referred to clause 1 of Article 132 or clause 1 of Article 133 or as the case may be the clause C of clause 1 of Article 134 may be given in respect of that case. Article 135 Jurisdiction of powers of the federal court under existing laws. Jurisdiction and powers of federal court under existing law to be exercisable by the Supreme Court. Jurisdiction Jurisdiction and powers of the federal court under existing law to be exercisable by the Supreme Court until Parliament by law otherwise provide the Supreme Court shall also have jurisdiction and powers with respect to any matter to which the provisions of Article 133 or Article 134 do not apply if jurisdiction and powers in relation to that matter were exercisable by federal court immediately before the commencement of this constitution under any. What are the article and okay. These are the laws. Article 136. Special due to appeal by the Supreme Court, notwithstanding anything in this chapter, the Supreme Court may, in its discretion, grant special due to appeal from any judgment, decree, determination, sentence, or order in any cause or matter passed or made by any court or tribunal in territory of India. Clause 2 of Article 130. Nothing in this in clause 1 shall apply to any judgment, determination, sentence, or order passed or made by any court or tribunal constituted by or under any law relating to armed forces. Okay, so the armed forces have the Supreme Court cannot meddle in the matters of armed forces. Article 137. Review of judgments or orders by the Supreme subject to the provisions of any law made by Parliament or any rules made under Article. The Supreme Court shall have an power to review any judgment pronounced or made by it. Okay. Article 138. Enlargement of the jurisdiction of Supreme Court. The Supreme Court shall have such further jurisdiction and powers with respect to any of the matters in the Union list as Parliament by law confer. Uh, Laws to Article 138. The Supreme Court shall have such further jurisdiction and powers with respect to any matter as the government of India and the government of any state may by special agreement confer. If Parliament by law provides for the exercise of such jurisdiction and powers by the Supreme Court. Conferment on the Supreme Court of powers to issue certain writs. Parliament by law confer on the Supreme Court power to issue direction, order, or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and century or any of them for any purpose other than those mentioned in clause 2 of Article 132. Okay, I have forgotten everything. What was Article 32 or like that? Let's see. I have to check what this means. I have to check what this means. Okay, okay. Uh, yeah, this Article 139A, transfer of certain cases, where cases involving the same or sustainability uh, or substantially the same question of law are pending before the same Supreme Court and one or more high courts or before two or more high courts and the Supreme Court is satisfied on its own motion or on an application made by Attorney General of India or by a party to any such case that such question are substantial question of general importance. The Supreme Court may withdraw the case or cases pending before the High Court or High Courts and dispose all of the cases itself. Okay. Provided that the Supreme Court may, after determining the said question of law, return any case so withdrawn together with a copy of its judgment on such question to the High Court from which the case has been withdrawn, and the High Court shall on receipt thereof proceed to dispose the case in conformity with such judgment. So basically, the Supreme Court can take up a court from the High Court case that is going on in High Court and order the High Court to pass out it to them. I guess the Supreme Court may, if it deems expedient, so to for the ends of justice, transfer any case, appeal, or other proceeding pending before any High Court to any other High Court. Okay, so the Supreme Court can also transfer cases from one high court to another high court if it finds necessary. Ancillary 140 ancillary powers of Article 140 ancillary powers of the Supreme Court. Parliament may by law make provision for conferring upon the Supreme Court such supplement powers not inconsistent with any of the provisions of the Constitution as may appear to be necessary or desirable for the purpose of enabling the court more effectively to exercise the jurisdiction conferred upon by it by or under this constitution. Okay, so yeah, it is very unimportant, I guess. Article 141. Article 141. Law declared by Supreme Court to be binding on all courts. The law declared by Supreme Court shall be binding on all courts within the territory of India. Okay, it is pretty I mean, self-evidently self-evidently true. Article 142. Enforcement of decrees and orders of the Supreme Court and orders and discovery, etc. The Supreme Court, in the exercise of its jurisdiction, may pass such decree or make such order as it necessary for doing complete justice in any cause or matter pending before it, and any decree so passed in order so made shall be enforceable throughout the territory of India in such manner as may be prescribed by or under any law made by Parliament, and until provision is that behalf is so made in such manner as the President may by order prescribe. Oh man, I mean the language is extremely dry and complex. The English language written here, and I actually am, my cognitive capacity is decreased if I read out loud the Constitution out loud instead of reading in my head. My ability to understand it is also severely weakened because I don't read books out loud. I read them in my head. Okay. What is the decree? Hmm. Okay. Okay. And orders of discovery. Subject to the provisions of any law made in this behalf by Parliament, the court shall, as respect the whole of territory of India, have all and every power to make any order for the purpose of securing attendance of any person, the discovering of or production of any documents, or the investigation or punishment of any contempt of itself. Article 143. Power of the President to consult the Supreme Court. Okay. I mean, like, the president is just, the president doesn't have that much powers, man. It is just the ruling party's sipahi. If at any time it appears to the president that question of law or fact has arisen or is likely to arise, which is such a nature and of such a public importance that it is expedient to obtain the opinion of the Supreme Court upon it. He may refer the question to that court for consideration, and the court may, after such hearing as it thinks fit, report the president its opinion thereof. Okay. I mean, like, why you are writing this? I mean, why is this article written where? Like, obviously, the president will, go and seek help of the court in matter of law. Clause 2 of Article 143. The president may, with notwithstanding anything, the proviso, I think there is a word mistake or this PDF's mistake. Proviso to Article 131. Refer a dispute of the kind mentioned in said provision or proviso. I don't know, man. I think this is proviso. Wait. I want to see. Is proviso or proviso? What is it? Okay. It is proviso. It is not a word mistake or the mistake done by the PDF. Notwithstanding anything in the proviso to Article 131, refer a dispute of any kind mentioned in the said proviso to the Supreme Court for opinion, and the Supreme Court shall, after such hearing as it thinks fit, report to the Pope, to the President its opinion thereon. Ah, Article 144. Civil and judicial authorities to act in the aid of the Supreme Court. Okay. All authorities. civil and judicial in the territory of India shall act in aid of the Supreme Court. Article 144A. Okay, so that means I think the police come under the civil authority, I guess, in India. So even the police can help Supreme Court. Dire times. That's the police come under civil authority. Yeah. Good thing, man. Supreme Court has lots of power, man, compared to the useless power of president. Supreme Court has real powers. Special Article 144A, special provision as to disposal of question relating to constitution validity of laws omitted by the Constitution, 43rd Amendment. Okay. Article 145, rules of court, etc. Subject to the provisions of any law made by Parliament, the Supreme Court may from time to time, with the approval of the President, make rules for regulating generally the practice and procedure of the court, including rules as to the person practicing before the court, rules as to the procedure of hearing appeals and other matters pertaining to appeals, including the time within which appeals to court are entered, rules as to proceeding in the court for the enforcement of any of the rights conferred by Part 3, rules as to proceeding in the court under Article 139A, rules as to entertainment appeals under subclause C of Clause 1 of Article 134, rules as to conditions subject to which any judgment, pronounced, or order made by the court may be reviewed, and the procedure for such review, including the time within which application to the court for such reviews are entered. Okay, man. Another rules which are not useful for me. These are the rules that can be made by the Supreme Court, like how day-to-day operating of Supreme Court happen, I guess. Rules as to cost of incidents or any proceeding in the court and as to fees or to be charged in respect of proceeding therein. Rule as to granting of bail. Rules as to stay of proceedings. Rules providing for the summary determination of appeal, which appears to the court to be frivolous or vexatious. I don't know these two of words, man. I don't know what they mean. I don't know. Let's see what the word means. Frivolous and virtuous. Any serious purpose or merit, legal foundation typically. Okay. So these are the false accusations or accusation made to waste the time of the court. Rules as to the procedure for inquiry referred to in clause 1 of the article 370. Okay. Subject to the provision of the clause 3, rules made under this article may fix the minimum number of judges who are to sit for any purpose and may provide for the powers of single judges and division courts. The minimum number of judges who are to sit for the purpose of deciding any case involving a substantial question of law as to the interpretation of the Constitution or the purpose of hearing any reference under Article 143 shall be 5. Okay. Provided that where the court hearing an appeal under any of the provision of this chapter rather than Article 132 consists of less than 5 judges, and in the course of the hearing of the appeal, the court is satisfied that the appeal involves a substantial question of law as to the interpretation of this Constitution, the determination of which is necessary for the disposal of the appeal. Such court shall refer the question for opinion to a court constituted as required by this clause for the purpose of deciding any case involving such a question, and shall, on receipt of the opinion, dispose of the appeal in conformity with such opinion. Okay. So the judgments or cases which have extreme, what is called, question of law, substantial question of law as this interpretation of this constitution, the determination. Okay, so it can have only 5 judges, or they can seek the advice from the 5 judges, I guess. No judgment shall be delivered by the Supreme Court save in open court, and no report shall be made under Article 143 save in accordance with an opinion also delivered in open court. Yeah, I don't understand what this means. Clause 5, no judgment and no such opinion shall be delivered by the Supreme Court save with the concurrence of majority of the judges present at the hearing of the case. But nothing in this clause shall be deemed to prevent a judge who does not concur from delay a dissenting judgment or opinion. Okay, so judges can deliver a dissenting what judgment? Like in the, I think the Ram Janmabhoomi temple, one judge out of the 5, didn't agree with the judgment. Okay, I think that means that, and I think Ram Mandir was definitely a substantial question of law or interpretation of law. 146 officers and servants and the expense of the Supreme Court. Okay, another useless clauses. I mean, you should have written another book for that. This server, what officer, servants, and the expense of the Supreme Court. Yeah, there should have been another book. Clause 1 of Article 146. Appointments of officers and servants of the Supreme Court shall be made by the Chief Justice of India or such other judge or officer of the court as he may direct. Okay. Provided that the President may by rule require that in such cases as may specified in the rule, no person or not already attached to the court shall be appointed to any office connected with the court, say after consultation with the Union Public Service Commission, UPSC. Okay, so okay, the Supreme Court Chief Justice can only nominate the or choose the officers and servants which will be doing the jobs in Supreme Court, and also they cannot be connected to the court before their hiring. Okay, subject to the provisions of any law made by Parliament. The condition of service of officer and servants of the Supreme Court shall be such as may be prescribed by rules made by the Chief Justice of India or by some other judge or officer of the court authorized by the Chief Justice of India to make rules for the purpose. Provided that The rules made under this clause shall, so far as they relate to salaries, allowances, leave, or pension, require the approval of the president. 3. Clause 3 of Article 146. The administrative expenses of the Supreme Court, including all salaries, allowances, and pension payable to or in respect to the officers and servants of the court, shall be charged upon the Consolidated Fund of India, and any fees or other monies taken by the court shall form part of that fund. Okay. Okay, Article 147, Interpretation. In this chapter and in Chapter 5 of Part 6, I guess. Yeah, it is 6. In this chapter, and in Chapter 5 of in this chapter and in Chapter 5 of Part 6, references to any substantial question of law as to the interpretation of this constitution shall be construed as including references to any substantial question of law as to the interpretation of the Government of India Act 1935. I mean, why the heck we have, there is a saying that goes that Indian Constitution is two-third taken from the Constitution of India 1935, or the Raj Constitution of India, which is I mean, it is very bad, man. How can you take a constitution which is made to control people and subjugate them, repress their dissent? How can you do that? Including any enactment, amending or supplementing that act, or of any order in council or order made under or of the Indian Independence Act 1947, or of any order made thereunder. Okay, so this is interpretation of the law where you can take, what you can take references from previous judgments, which also involve that kind of thing, and guide the court to make the decision, I guess. At least that is how I read this. Okay. Article 148. There shall be comptroller and auditor general of India who shall be appointed by the president by warrant under his hand and seal, and shall only be removed from the office in like manner on the like ground as judge of the Supreme Court. Okay. Every person appointed to be the comptroller and auditor general of India shall, before he enters upon his office, make and subscribe before the president or some person appointed in that behalf by him an oath or affirmation according to the form set out for the purpose in the third schedule. Clause 3. The salary and other condition of service of the comptroller and auditor general shall be as may be determined by Parliament by law, and until they are so determined shall be as specified in the second schedule. Provided that neither the salary of comptroller and auditor general nor his right in respect to leave of absence, pension, or age of retirement shall be varied to his disadvantage after his appointment. Clause 4. The comptroller and auditor general shall not be eligible for further office either under Government of India or under the government of any state after he is who hold his office. Who is the current Comptroller and Auditor General of India? Let's see. Okay, Sri K. Sanjay Murthy as of late 2024 and 2020. Auditor General. It's Sanjay Murthy. It's that there shall be control. I already the control and auditor general shall not be eligible for the subject to the provision of this constitution and any law made by parliament. The condition of service of person serving in Indian audit and account department and the administrative powers of the control and auditor shall be such as may be prescribed by rules by the president of the constitution with control and auditor. The administrative expenses of the office of the control and auditor general, including all salaries, allowances, and pensions payable to or in respect to persons serving in that office, shall be charged upon the consolidated fund of India. Article 149. Okay, I'm gonna stop after Article 1. This because my brain is not right. I cannot go further. Article 149. Duties and powers of Control and Auditor General. Control and the Auditor General shall perform the duties and exercise such powers in relation to the accounts of the Union and the states and of any other authority or body as may be prescribed by or under any law made by Parliament and until provision in that behalf is second shall perform such duties and exercise such powers in relation to the accounts of the Union and of the states as were controlled or exercised by the Auditory General of India immediately before the commencement of relation to the accounts of the Dominion of India and province. Okay, I don't know what is written here, duty and powers of government. I am unable to inference from this, like what is written. Okay, wait, I'm gonna look it on internet. What com, com controller, I guess, comptroller and auditor general can do. Okay, so they are like a general manager, bank or bank manager of the consolidated funds of India. They keep the records and all this, I guess. They are basically manager, bank manager type of consolidated fund of India, I guess. Mm. Article 150, form of accounts of the Union and of the state. The accounts of the Union and of the state shall be kept in such form as the President may, on the advice of the Comptroller and Auditor General of India, prescribe. Audit reports. This is the last. Article 151. Audit reports. The reports of the Comptroller and Auditor General of relating to the accounts of the Union shall be submitted to the President, who shall cause them to be laid before each House of Parliament. Clause 2. The reports of the Comptroller and Auditor General of India relating to the accounts of state shall be submitted to the government of the state, who shall cause them to be laid before the legislature of state. Okay. So the Comptroller or Auditor General of India is some like a bank manager who keeps the uh, you know information of the accounts and information of the accounts of the state and the union. Okay. Yeah, man, this constitution is extremely difficult book to read, and I don't read books, out loud, and that's why my brain is also not its full potential. Yeah, I will. I am trying my best, but I think this is not, good enough understanding of the constitution by me. But I will continue the reading of the constitution, and if required, we will also have second reading I find it necessary. If don't, if I don't find it, then yes, I will not read it. And my brain is already fried. I cannot go further. Just 44 minutes in. Yeah, the language of this book is extremely difficult, and it has lots of words that are, jur- jurisprudence of the law and all these things. Law related words which I don't know or understand. That's why the difficulty.